各位委員，咁我哋呢
Members, it's the appointed time. We have a quorum. Let's get started. Good morning. Agenda item 1, meeting with the administration. Let's ask our officials to come into the meeting room first.
另外呢都提提大家啦。
I'd like to remind members, well, you may have received it already. The administration proposed some amendments yesterday. The Chinese version has been issued to members. The English version has been tabled to members.
好，咁喺度呢歡迎政府。
Welcome, administration's representatives. Now we come to matters arising from previous meeting held on the 19th of January. The administration has made a reply to issues raised at that meeting. Please refer to LC paper number CB bracket 1235/2024 bracket 02. Administration, when you're ready, please walk us through the paper. Thank you, Chairman. I thank members and the deputations for the views after the meeting on the 22nd of January. We received some inquiries and we have provided supplementary information based on those inquiries. We have a few points to add here. This includes whether feral pigeons will be able to look for food themselves after the bill is passed. According to our experts and information collected, it is the natural instincts of feral pigeons to forage for food, so it doesn't require feeding by humans. So after the passage of the bill, it won't accelerate the reproduction of feral pigeons. It won't cause more nuisance to the public. There are similar measures put in place in other places concerning feeding ban. In the previous meeting, we have explained to members about these points, so we won't go into the details here. The purpose of the feeding ban is to minimize impacts on environmental hygiene. And the other purpose is to protect wild animals. If we see a growth in population of feral pigeons, it will cause ecological imbalance. It will also affect other wild animals. In the meeting on the 22nd of January, some groups and deputations mentioned whether there are ways or other ways to control the population of feral pigeons. This includes contraceptive measures or pigeon lofts, as well as educational programs. In our paper, we mentioned that government departments, especially AFCD, has all along been implementing programs to control or minimize the nuisance caused by feral pigeons. We have been implementing educational programs as well as contraceptive programs. And in the course of it, we have been liaising with relevant organizations as well as schools. We see effectiveness of these programs, but the effectiveness is limited. That's why we think that the feeding ban is necessary. Some deputations mentioned issues about a fixed penalty. We propose a $5,000 fine for the fixed penalty, and it is a higher level, and we explained the rationale behind it in the paper. According to CAP 570, the fixed penalty for littering is $3,000. As mentioned, apart from environmental hygiene issues, feeding of feral pigeons will also attract the ecology as well as other wild animals. That's why we are proposing a fixed penalty of $5,000 for prohibited feeding of feral pigeons. There are also views concerning enforcement. As stated in our paper, if in the future members of the public want to lodge complaints, we welcome complaints to be made through the 1823 hotline, and the relevant government departments will take enforcement actions and provide enough resources for that. I'm going to make a few more points about some relevant issues. I believe we can have a more detailed discussion and during the clause-by-clause examination. So, but I won't go into the details here. If members would like to ask questions based on the administration's reply, please press the button. If you have questions concerning the bill, I suggest that you raise them during the clause-by-clause scrutiny. 4 minutes will be given to each member, questions and answers inclusive. Mr. Tony Che. Thank you, Chairman. As mentioned in the paper, feral pigeons have the ability to forage for food on their own. After the passage of the bill, it is believed that there will be a drop in population of feral pigeons. If we just rely on the feeding ban to control the population of feral pigeons and minimize the nuisance caused to the public, it may not be necessary. There should be other measures in place. So my first question is, does the administration have any thoughts on how many feral pigeons the bill will help to reduce? Will there be any indicators? Also, there's mentioning about the progressive penalty system. The government's view is that it may make things complicated for repeat offenders. The administration may make prosecution by summons. Well, we've been talking about e-government services. Will enforcement officers be able to check expeditiously the record of repeat offenders? Then they will consider whether they should make prosecution by summons or by issuing fixed penalty notices. Also, on possession of hunting appliances, is there any further information that can be supplied by the administration? I'll invite Mr. Chan to reply to that. I thank member for the questions on the feeding of feral pigeons. To ban the feeding, we have a series of measures in place to control the number of feral pigeons. Apart from contraceptive programs, we have a whole plan to educate the public, to advise members of the public not to feed feral pigeons. This is in hopes of minimizing nuisance caused by feral pigeons. After the passage of the bill, we will continue to conduct surveys on the population of feral pigeons, and will also keep track of the complaints we receive. Then we will see whether we should adjust the measures in place. Currently, we don't have any indicators set yet. The population of feral pigeons in different districts varies. Some districts may see more feral pigeons, and the number of complaints for each district also varies. We will, based on the situation, adjust our measures. On the question about fixed penalty and electronic system, we are currently devising an electronic system for the fixed penalty. To track the records of repeat offenders, we'll have to rely on another system. And currently, we don't have that particular system in place yet. We will consider whether we should create such a system to include all records of repeat offenders. On the questions about hunting appliances, according to Wildlife Protection Ordinance, it is prohibited to possess hunting appliances. In the past, some people stole hunting appliances from other places and brought them to Hong Kong. So the Customs and Excise Department has been making enforcement. We are also stepping up search on hunting appliances, especially in countryside. If we spot any hunting appliances, we will step up patrol and inspection to combat on possession of hunting appliances. Chairman, can you ask the administration to provide information on statistics and figures on previous enforcement actions? Does the administration have the relevant information? We will supply information about prosecution numbers as well as information relating to enforcement action after the meeting. Mr. Lam Chun Sing. Thank you, Chairman. In the last meeting, I asked about enforcement officers as well as manpower. In the administration's paper, it has listed out all the grades and ranks of officers that can take enforcement actions. They are mainly from the FEHD and LCXD. Will the administration have to give an written appointment to these officers before they can take enforcement actions? It's not like they can take enforcement actions whenever they want. It will have to depend on how many appointments you issue before we know how many officers can take enforcement actions. You have listed out different grades and ranks here. It looks like you are going to ask different types of officers to take enforcement actions, say for librarians and managers responsible for cultural projects. Well, entry requirements or duties given to them do not include taking enforcement actions. So does it make sense to ask these officers to take enforcement actions? It's not their day-to-day duty to take enforcement. There are a lot of follow-up duties they have to do after taking enforcement actions. For instance, they'll have to take care of the prosecution documents. Does that mean this will increase the workload of these officers? They may not do the work well anyway because they're not used to enforcing the law. Would you have officers dedicated to enforcing the law in relation to the feeding ban? These officers will have undergone training and they will be able to better take forward their duties.
And lastly, I'd like to put a question about the visitors. Some members raised this before. I've been to the Tsim Sha Tsui staff area pier near the 5 flag posts. There are so many pigeons. If the visitors are feeding the feral pigeons, they may not be aware of the legislation. Will there be any lenient treatment when the law comes into place? in the mainland websites, I haven't seen any wide publicity about visitors being able to feed the feral pigeons in Hong Kong. But when the law is first in place, will you be adopting more lenient treatment regarding enforcement? I defer to Mr. Sheck, and I supplement if necessary. Chairman, thank you. Thanks very much for the question. First, about the written authorization. It's going to be in the form of an appointment letter. I've got a sample here with me. It's more like a letter, and a copy of this letter would be sent to all the enforcement departments and teams, and they will be enforcing the law armed with this particular appointment letter showing that they've got authorization to take enforcement action. We can see that different departments have submitted a list of colleagues to assist in the law enforcement. For the AFCD, we do have a dedicated team, and there is a clear division of work. Some would be responsible for the feral pigeons. Others would be responsible for the other wild animals. So with this authorization there, we have officers from different grades instead of individual officers. That would make things easier. For the visitors at the boundary control points, we do mount publicity about this particular piece of legislation. As and when this comes into force, there will be more publicity at the BCPs. For places where more people tend to feed the feral pigeons, we will be putting up the banners to advise the visitors and the members of the public against the feeding of pigeons. Thank you. Mr. Lam's question, I'm sure that you have the list of enforcement officers, like the librarian, chief librarian, is also tasked to do this. Is it a question of authorizing him to do the job, or is it the case that really the chief librarian will have to do this kind of work? That is something they would like to ascertain. Have you discussed with the departments? As and when this bill is enacted, we will be discussing with the departments about this kind of frontline work. That the chief librarian is included, but I'm sure that the enforcement work will be in the hands of the frontline officers. We hope that in areas where the departments have jurisdiction, if they come across this kind of illegal feeding, they can take enforcement action. I'm sure that they would have frontline officers to do the work. When this bill is passed, there will be training to be provided to the frontline officers. We're going to be issuing the enforcement guidelines to facilitate the enforcement work. Chairman, thank you. My understanding is the same as the chairman's. You have a whole list of the officers there. I mean, it's like all hands are on deck, and it may not be good enough because many of them are not responsible for enforcement work in the first place. And like the department said, the AFCD may have a designated team of officers responsible for enforcement. That's a more appropriate course of action. Ms. Doreen Kong, please. Chairman, thank you. Just a moment ago, the department showed us the letter of appointment. Under the law, this has to be displayed. If asked, there would be too much hassle for them to go around armed with this particular letter. Unless you laminate it, it would it would be rotting very easily. But would you be doing the same thing as the police? I mean, it's too much hassle for them to produce this paper form appointment letter all the time. Thank you. Thanks very much for the comments. This is really a sample to show members that there is going to be such a letter of appointment. And this can be captured on the cell phone in a digital form or format. They don't necessarily have to carry this paper-based or laminated letter of appointment all the time. Now we can certainly discuss how this can be done. Well, this is to facilitate the law enforcement officers. And there may be many letters of appointment. It would be really difficult for them to carry them all. Ms. Kong, I don't agree with the digital format because it's liable to be fabricated. But are they in uniform? All these law enforcement officers, are they in uniform? Well, the librarian, I don't think they are in uniform. Well, that's the case, Chairman. Thank you. So I don't think we should have a digital format. This is really risky. They're not in uniform. If you use the digital format, it's very easy for people to fake them. I think it would be a good idea for them to have kind of a badge with proper top on it. Is it feasible? My point taken. We'll look into this. The idea is to have the paper-based format. But I've heard what members have to say, and we'll have a look at this. Well, I hope that you would consider the details. When it comes to the actual enforcement, it would be difficult to produce a paper-based letter. If there is a QR code, people can scan the QR code for the details. It would be a feasible proposition. This will facilitate the enforcement work. Anything else, Madam Kong? No? Ms. Judy Chan, please. Chairman, thank you. I welcome this amendment because, as we can see, there are so many hygienic problems arising from the illegal feeding of feral pigeons. And with this amendment exercise, I hope that we can make a difference to the situation where the pigeons congregate. My concern is, other than public places, there are many premises or private places where people would be generous enough to feed the pigeons by just opening the windows and feeding the pigeons like that. They may have a window sill, a window ledge where they can do this. That the feeding ban area covers all public places and private places and premises, but there may be some housing estates in which where the management would think that it would be difficult for the government to enforce the law in these private premises. It's just like the water seepage. The joint office would find it terribly difficult to gain entrance into the premises. They're really banging their head against the brick wall many times. Now, people may be filming the water seepage, and they cannot really get anywhere with the solution. So how are you going to be publicize this particular piece of legislation to make people aware that you are able to gain entrance to the premises to enforce the law, and you have the authorization, and you're going to be working in collaboration with the management company? Thank you. Thanks very much. Mr. Shank, please. Thank you for the question. Indeed, in private premises, it does present some difficulties, but our experience shows that we did manage to handle cases like this. We would send colleagues to conduct investigation. We will be communicating with the property management officers to gather what evidence we need, and where necessary, we will be getting in touch with the premises to get the details. If sufficient evidence exists, we will take our prosecution. Ms. Chen? Well, so many departments are involved in law enforcement. Now, if we can gather the evidence, will the department be able to take our prosecution? Thank you. We do have division of labor. When it comes to the public housing estates, it would be for the housing department. For private places or premises, it would be within the remit of the AFCD. If the housing department experiences any difficulties, the AFCD would be rendering assistance, like we can mount joint action to tackle the cases. Ms. Chen, I do hope that you would ramp up the publicity efforts, some posters, some leaflets, flyers to be distributed. And you should publicize these no feeding zone in large font, and also let people know they're not supposed to be feeding the pigeons in their own premises as well. Ms. Doreen Kong, I'd like to follow up on this. Now, for private premises, that you really need to get a warrant to gain entrance, or can you just walk in? Thank you. Thanks very much for the question. Now, for private premises, the AFCD can apply for a warrant to gain entrance. Thank you. I've got a comment to make. Now, should this bill be passed, it is really necessary for you to step up publicity. I hope that you would reserve some resources for that. Second, Mr. Lam Chen-sing mentioned the visitors to Hong Kong. I hope that you would issue some reminders. And you said a moment ago that there would be some reminders at the BCPs. Now, at the black spots, I hope that you will be putting up some notices. When they came through the border checkpoint, they probably wouldn't pay attention to the notices. But if you put up some notices specifying the maximum penalty, I mean, that would achieve some deterrent effect where the black spots are. All right, in terms of policies, any further comments? If not, we've been having some meetings. We also had some public hearings. I'm sure that we have already ventilated our views regarding the policy matters. So unless you have any further views, let's get started with the clause-by-clause scrutiny. Will members please refer to LC paper the bill, as well as the marked up copy, LC paper number CB11131/2023 bracket 01. And the administration has presented a paper on amendments. That's LC paper number CB1266/2024 bracket 01. The administration might wish to elaborate on the CSAs there in the course of the clause-by-clause scrutiny. Are we going to do the Chinese version first or the English version first? I propose that we deal with Chinese version first, and I'll be consulting the legal advisor to see whether there is anything untoward regarding the English version.
So that's what we're going to do. I'll ask the administration to walk us through the bill. please refer to the bill. I'd like to first talk about the long title. According to the long title, this amendment is to step up the penalty for feeding of feral pigeons. This is also to prohibit the feeding of feral pigeons and will provide for certain exceptions to the prohibition on feeding those animals. We're also going to provide for a fixed penalty for contravention of the feeding ban. We will also appoint specified officers for the purpose of enforcing the fixed penalty, and we will amend the categories of persons who may act as authorized officers and will make consequential amendments. And the amendment will take effect in April 2020, on the 1st of August 2024. Please refer to the marked up copy. On page 2 of the marked up copy, we have amended several definitions of terms. For some outdated definitions of authorized officers, we have made amendments. Authorized officer will mean a police officer and a public officer belonging to a class of public officers appointed by the director under section 16(1). We have also added a definition for specified officers. We'll elaborate on that later. On page 3 of the marked up copy, we have added a section 9A. This is to replace section 17(c) of the original ordinance. This is about prohibiting the feeding of wild animals, and we will add a schedule which entails a list of specified animal, and feral pigeons will be added to the schedule. In the provision, we provide for certain exceptions. The ban will not be applicable to feral pigeons kept in captivity, and permit will have to be obtained prior to feeding feral pigeons. In order to more accurately reflect our legislative intent, it is the feeder that has the responsibility to provide defense. We will provide for exceptions, and we will set out clearly in the provision that it is the burden of the feeder to provide defense or burden of proof. Mr. Lai Tong Kwok, I thank the administration for taking on board members' views. The proposed legislative amendment will enhance the clarity of our existing provisions. This will avoid disputes in the court between different parties on which party has the burden of proof. I would like the administration to provide supplementary information on this after the meeting. Please carry on. Thank you. Page 4 of the marked up copy. We are proposing amendments to the existing section 15 of the ordinance. We are going to have a new section 9A to replace the existing provision. Page 5 of the marked up copy, we are amending section 16. It is to remove the part about nature wardens and honorary nature wardens under authorized officers. Instead, the director may appoint any public officer or class of public officers to serve as authorized officers. If there is reasonable request made by the feeder, then the authorized officer will have to produce his or her appointment for inspection. We've noted members' views, and in order to enhance clarity of this provision, we have, prior to the meeting, produced a proposed amendment. We think we have to make it clear that if someone reasonably requires to see the written appointment, then the officer will have to produce the officer will have to produce the appointment for inspection. The English versions will remain unchanged, but we have made some amendments to the Chinese version. Legal advisor has something to say. Thank you, Chairman. On the newly added Section 16, members asked about the supply of appointment and whether the officer in question can provide a different type of appointment like a card. Well, in the English version, it's currently pointing to an appointment. In Chinese, it says 委任书. Under the current law, some officers may be authorized to take enforcement actions, and the term currently used in existing law is warrant card. If the authorized officer has to produce a written appointment, well, the administration mentioned that it can be replaced with an appointment card or a warrant card. What is the rationale behind, and will the wordings have to be adjusted here if a warrant card or an appointment card will be shown instead of a written appointment? I'll ask the government counsel to reply. In the bill, the appointment letter is a written form of appointment, and it encompasses a very broad meaning. It can be a card or it can be a piece of paper. If it is clearly written on the card that the person concerned is an appointed officer, then it should be fine. As to whether different wording can be used to express the written appointment, we will look into it to see how we should adjust the wording. Members may consider whether the reply given by the administration can ease your concerns about the appointment letter. Mr. Lai Tong Kwok. Thank you, Chairman. Be it a written appointment letter or an appointment or a warrant card, what matters is that the authorized officer has the written appointment for inspection. I don't think the wording here is a point of concern. What matters is whether the authorized officer has the written appointment. Just now, the administration showed us an A4 size paper. If it is not laminated, as Mr. Oren Kong said, it may be crumpled. You're mostly asking enforcement officers to issue fixed penalty notices. I don't know how large the fixed penalty notice would be. According to fixed penalty notices issued for illegal parking, the piece of paper is quite big. So there should be a cover to the fixed penalty notice. If you can design it and to make it smaller, well, for instance, say this is the fixed penalty notice, and there is a hard cover on the back. And say if you can make it smaller and you put the ticket here, you may include the appointment letter in this stack of notices that you're going to issue. And you can make sure that you won't lose the appointment letter because you'll have to issue the ticket. And if you attach the appointment letter there, then that should be fine. That's one way to solve the issue. You can make it in the size of a credit card, for instance, and you can use smaller font to clearly spell out that the officer in question is an authorized and appointed officer, and there can be a photo of the officer. There can also be the signature of the director. Well, there can be different forms for the appointment letter. What matters is, like the legal advisor said, it has to comply with the law. There can be disputes over the term. I agree with what Ms. Doreen Kong said. It may be problematic if you use digital version of the appointment letter. Some people may impersonate the enforcement officers. Say someone produces a digital version of the appointment letter, and the person may be with the intent to deceive others. So you have to avoid all these situations. You don't want to make it too convenient. If people see that you're carrying a stack of fixed penalty notices to be issued with the appointment letter attached, there will be a smaller chance that people can exploit the system or make use of the loopholes. That's my view, Chairman. Ms. Doreen Kong. I would like to make a suggestion. Can we, under the new section 16 bracket 2, change the wording for Chinese 查看有關書面證明, for English to produce appointment for inspection or proof of inspection. Can we use the word written evidence of appointment to make it more flexible? DOJ, any response? Is a member's suggestion feasible? Thank you, Chairman. I thank member for the suggestion. Written evidence of appointment would make it more flexible because it is referring to a proof instead of a card or a letter per se. We will look into how we should phrase it. Would it be better if we allow more room for flexibility? If you use a broader term, then it will allow more flexibility. Well, like Mr. Lai Tong-kwok said, there are worries that there may be disputes when the case is taken to the court in the future. We have to think about this. Some tourists, they come to Hong Kong, they have no idea about this ordinance. Say someone produces a digital version of the appointment, and that person impersonates enforcement officers and tell tourists that they have to pay $5,000, otherwise they will be banned from leaving Hong Kong. Well, there were examples like this before. How can we minimize such situations? The way we phrase it here will facilitate enforcement officers to produce a physical version of the appointment. So DOJ will have to look into how you should adjust the wording to allow more flexibility here to ensure that the enforcement officers have to show the physical version of the appointment.
Yes, members would like to have the physical form and make it smaller to make it portable. Right, unless I have any further points, then let's carry on. Page 6 of the marked up copy, 17C, the outdated provision is removed, and we've added 17D, the authorized officer may, for the purpose of issuing and serving a summonses, the person should supply the name, address, and contact telephone numbers for inspection. And that's on the basis that the suspect has committed the offense. We did have some chat with members, and 17D2 can be further revised because at the present moment we say that the authorized officer can issue a notice. Now, a notice includes a penalty notice. And in our paper submitted before the paper, we have supplemented this point, and we are proposing a CSA there for notice. We would include the penalty notice as defined in Section 1.1 of the new Schedule 9 under the bill. Mr. Lai Tung Kwok. Chairman, I support this amendment myself because this will remove all potential controversies, and this is a good amendment. Mr. Doreen Kong. Chairman, thank you. 17D1. If an authorized officer has reason to believe that this is a common phraseology in law, but can you tell us here, when it comes to the actual operation on the ground, now you see people feeding the pigeons, but why do you have to say have or has reason to believe? Please let the public know why you have to couch it like this. Now, you discover people feeding the pigeon, and or you have evidence to show that people have fed the pigeon. Why has reason to believe? Now, let's say I've got a lot of rice, grains of rice in my pocket. You have reason to believe. Can you arrest me? Now, if a person is suspected by the residents to be feeding the birds, but he has a loaf of bread in his bag, and under 17D, the way it is couched, and also this person, this person is rumored to be really fond of feeding the pigeons, and under 17D1, then you can ask for the proof of identity. Do you have to make it so broad? Reason to believe. This is couched in really broad terms. Would that infringe people's privacy? Now, if he's feeding the pigeon, serve him right. But if he is walking around with a loaf of bread, would it be really too broad under 17D1? Has reason to believe. DOJ? Thank you, Chairman. Thank you, Member. Here has reason to believe. What one has to believe is one has committed the relevant offense. So the officer must have the reason to believe that someone is committing or has committed a relevant offense. The member mentioned that there may be some grains of rice in his pocket, but if he's not feeding these to the bird, then we cannot say that he is committing or has committed a relevant offense. I'm sure that the officer has to witness him in the act before the penalty notice can be issued. So I'm not sure whether the department sees likewise. Yes, I go along with the DOJ. In fact, if an officer has witnessed that someone is committing or has committed an offence, then action will be taken. Ms. Kong, Chairman, the difficulty lies with has committed. Now, if he's in the act of feeding, it doesn't concern me, but you haven't seen him feed the bird. But here, you have reason to believe. Then you don't have to ask anybody. Now, let's say I'm done with feeding and someone is reporting. You come to me to ask for my information, then you have reason to believe that I have committed the offense. So this is filling me with a bit of concern here. I would say, I would protest, how do you know I did feed the bird? I am concerned about the difficulties with enforcement, right? This is a likely scenario that Ms. Kong raised. Any supplement, DOJ? Chairman, thank you. Thanks very much, Madam Kong. Straight away, I can think of a scenario in which someone complained about someone else feeding the feral pigeons. And if there is the surveillance camera and the officer may be going back to the footage and found someone has indeed fed the birds, then he has reason to believe that an offense has been committed. Now, this is one of the scenarios, but in fact, there are so many different scenarios in real life. The way we draft the law is to achieve the purpose that if someone has indeed committed an offense of feeding the pigeons, then the officer can issue the penalty notice. Ms. Kong, there are 2 points arising from the clarification. If I have something in my pocket and you are suspecting me and you cannot really issue a penalty notice to me, is that right? Or if someone is done with the feeding, you must have the evidence there before you would be asking an individual for the particulars or issue him with the penalty notice. Right, just clarification. Right, I do appreciate Ms. Kong's concerns because we are contemplating all these likely scenarios. And if 2 people have grudges against one another, if one of them is carrying a bag of rice, then he might be framed for feeding a pigeon. Now here you say that has reason to believe, or should there be really concrete reason? I mean, this is really broad. If the officer has reason to believe, then you may land people in trouble. And I mean, we are going into minute detail. We may be hair splitting, but is it a likely scenario? Thank you, Chairman. Well, has reason to believe for officers, one must have a reasonable ground to have this suspicion. And if this is not appropriate, then I'm sure that when the case goes to court, there would be proper judgment. Mr. Lai Tong Kwok, I think Ms. Kong has put forward a very interesting and eminently good point here. I think it all depends very much on the specific guidelines that you issue to the frontline officers, whether this is sufficient clear, whether there is any clarity. The way it is drafted, I think it is acceptable because first, the officer has reason to believe. He has reason to believe that an offense has been committed. This is the subjective judgment. If you say that he has a reasonable ground to believe, then you are imposing an objectivity, an objective test. So ordinary people, when seeing this, would believe this. Now, for the authorized officer, if he has reason to believe that such and such happened, then he can take the steps. We apply similar standards when it comes to law enforcement. That much we understand. Now, if we say has some reasonable ground to believe that someone is in act of committing the offense, or someone has already committed the offense, then you may or may not see it. Someone fed the bird and left. You didn't see it. By the time you arrest him, he has run away. He's done with the feeding. And you see him running, and you have reason to believe. Or if someone file a report, or the report may be malicious in nature. If someone is filing a report, if there is a policeman on beat patrol and he's going up to the police officer to say that a woman was molested, and there is a report filed with the police, an officer would have reason to believe that someone has committed molesting, and he can take action. The guy is there, and he has to be the witness. If he is fabricating the report, then he's committing another offense. So I think this is okay in that sense. Now, the consequence is that the officer would only ask for the name of the person concerned, and is asking for the name, the address, and the telephone number under 17D. And the officer is asking for all these details for the purposes of issuing a summons or a penalty notice or any other documents in relation to the relevant offense. And that's as much as it is. So by the look of it, it is okay. If we add further details, it may present obstacles in the way of law enforcement, and that it may be difficult. Thank you. Right, unless you have any further comments, this is sufficiently clear. Let's go on. Chairman, thank you. Pages 6 to 8, we are making amendments to Section 18 regarding offenses and penalty in A17C3. We are removing this. And page 7, we've added number 2. A person who contravenes Section 9A commits an offense and is liable to a fine of level 6 and imprisonment for 1 year. And clause 3, a person who fails to comply with a requirement made by the authorized officer to produce the particulars commits an offense and is liable on conviction to a fine of level 2 and imprisonment for 6 months. And page 8, 4 and 5, it provides that if someone fails to produce the proof of identity, then there is a defense there for the person. And clause 6, if someone supplies any information that is false or misleading, then he is liable on conviction to a fine of level 2 and 6 months imprisonment. And clause 7, if a person who resists or obstructs an officer exercising any power, then it is a conviction and a fine of level 5.
Let's pause here. I see that some members have questions. Ms. Doreen Kong. Thank you, Chairman. I'd like to see clarification on this for subsection 7 here. It has to be looked at together with 17D bracket 3 and schedule 9. It's a bit complicated here. I want to know if I understand this correctly. Say a person refuses to provide his personal particulars according to Schedule 9. Means the relevant specified officer can first make an arrest and bring the person who refuses to provide information to the closest police station. Then we go back to what is said in 17D bracket 3. Then the government can fine the person at level 2. So what I'm saying is that the officer has to first bring the person in question to the police station, and upon conviction, the person would be liable to a fine at level 2. Does that mean that an arrest will have to be made first? I'll ask Government Counsel to give a reply. Thank you, Chairman. I thank member for the question for subsection 7 here. What will happen is that an enforcement officer, when he sees that someone violates section 9A for feeding animals, then the enforcement officer will ask for personal information to issue a fixed penalty notice. If the suspect refuses to provide information upon request, then, as Ms. Doreen Kong said, the enforcement officer will have the power to make an arrest. Subsection 7 states that if the person concerned resists or obstructs the officer exercising his power, then he will be liable to a fine at level 5, which is up to $50,000. Chairman, I don't quite understand subsection 7 here. How would a person still willfully resist or obstruct a specified officer exercising his power? Does that mean the person may refuse to go to the police station? This is a new penalty. Subsection 7 is something different. That means if a person refuses to go to the police station, then the person will be liable to pay a fine. If he refuses to provide information, that falls under 18 bracket 3, but if he resists to be arrested, that falls under section 18 bracket 7. Is that right? Thank you. Well, refusing to provide information falls under section 18 bracket 3. If he refuses to be arrested, then that falls under section 18 bracket 7. Say a person is issued with a fixed penalty notice. Well, subsection 7 here says a person who willfully resists or obstructs a specified officer exercising his power, it's also a kind of obstruction that falls under section 18 bracket 7. Meaning that the person could be prosecuted because of this. Say a mother is feeding a pigeon and the daughter refuses the police officer to arrest her mother, the daughter will also be violating the law. Is that right? Well, I think the administration will have to make sure that all the enforcement officers are clear about this. Mr. Lai Tong-kwok. Chairman, I think Ms. Doreen Kong raised a very good question. There are different scenarios that we can imagine. Say a person violates the feeding ban, and then an enforcement officer asks for the person's personal particulars before issuing a penalty notice. If the person refuses to provide the information, that falls under Section 18 bracket 3. So if the person insists on not providing the information, then the officer can make an arrest. That's subsection 4. Say when the arrest is being made and someone nearby is obstructing the officer to do so. Well, we saw such situation during the blacklight violence. Someone may willfully resist or obstruct an officer exercising his power, then that person will also breach the law. You can also do something to that person who obstructs the officer. I think this provision here will allow enforcement officers to ensure smooth enforcement. Say a case is brought to the court and the person is convicted, then everyone will know this is prohibited. Then everyone will know that he will have to provide his proof of identity upon being asked by the enforcement officer. Without subsection 7, it will be very problematic and you'll see all kind of issues arising. I believe the administration has heard our views. All these provisions will facilitate enforcement actions, but again, enforcement officers will have to be clear about this. Please carry on. Thank you, Chairman. Page 9 of the marked up copy, we are adding a new section 18A, stipulating that the fixed penalty will be $5,000, and for the new section 18B, it states that the Legislative Council may amend fixed penalty and costs. Marked up copy, page 10. We are amending the existing section 22 of the ordinance, stating that the director may amend the schedule, but not Schedule 9. We're also proposing that the director may, by notice published in the Gazette, amend the newly added Schedule 2A, that is the list of animals apart from wild animals that are subject to the feeding ban. I have Mr. Rincon, I have a question about 18B. New section 18B states that the Legislative Council may amend the costs. Is it very common in other provisions? Do we have such a provision in other legislations? The so-called costs here, we see details of it in Schedule 9. For the flowchart of schedule, well, currently under the Schedule 9A, the fixed penalty is suggested to be $300. I'm just asking whether this is common in other legislations, say for instance traffic ordinances. Thank you, Chairman. This is commonplace in other legislations relating to fixed penalty. Well, if there are no further questions, please carry on. Thank you, Chairman. And on page 10 of the marked up copy, we are adding a new section 22A, which gives power of the Secretary for Environment and Ecology to specify the forms of fixed penalty notices. Page 11 of the marked up copy, we are making an amendment based on the existing section 24. And the rule about the director serving written notice will not be applicable to Schedule 9. Mr. Rincon, Chairman, I have a question here. I understand that you're excluding Schedule 9 here. Schedule 9 is about demand notice and penalty notice, and this is about Schedule 9. Schedule 9 also has a part about service of notice. It's not very clear here. Will you follow the magistrate's ordinance here? In Schedule 9, in relation to service of notice, say when an officer serves a fixed penalty notice, it will have to be handed to the person concerned face to face. If the person ignores the notice, then a demand notice will have to be served. According to Schedule 9, that demand notice will have to be sent to the address of the person concerned. If there are no further questions, well, Ms. Doreen Kong? Well, I believe it doesn't apply to a company because a company won't feed feral pigeons. Mr. Lai Tong Kwok? I just want to make sure about one thing. When the director, by notice published in the Gazette, amend Schedule 2A, would that be regarded as a subsidiary legislation? Does it have to go through the negative vetting procedure by the Legislative Council? Mr. Lai understands it correctly. This would entail a negative vetting procedure in the Legislative Council if the director, by notice published in the Gazette, amends Schedule 2A. Understood. Please carry on. Page 12 to page 14 of the marked up copy encompasses refinement of the ordinance. Through these changes, we are enhancing the clarity here. We are also adding a new Schedule 2A, listing out animals apart from the prohibited wild animals for which feeding is prohibited, and we are adding feral pigeons to the list. Page 16 to page 17 of the marked up copy, there is a technical amendment concerning Schedule 6. Pages 18 to 30, we're adding a new Schedule 9. The provisions in Schedule 9 are similar to that of the fixed penalty ordinance. On page 18, for the first part of Schedule 9, it contains interpretation of different terms, including authority and demand notice and so on. And Part 2 of the schedule states that the director may appoint in writing any public officer or class of public officers to serve as specified officers under FEHD, LCSD, and the Housing Department. We are proposing amendment under Section 2, Bracket 2. If anyone requires to inspect the proof of appointment, then the officer concerned will have to provide the proof. And the relevant proposed amendment has been submitted prior to the meeting to members for reference. I think this is similar to the question that we have just discussed about the appointment letter. The administration may consider whether similar amendments will have to be made here. For the newly added Section 3 here, if someone violates the feeding ban, then the officer may request that person to provide personal particulars. Ms. Doreen Kong. I want to ask about page 20 of the marked up copy, Section 3. Say if I issue a penalty notice to a person and I ask the person for personal information, well, what will happen if the person concerned is a tourist? I don't know if I have a confusion here. You said penalty notice will have to be handed out to the suspect face to face. If the penalty notice is issued to the person, would you still need the personal particulars? Well, what if the person is a tourist?
Right, in clause 3, the proof of identity means the documents referred to by the Immigration Department. This is similar to the other provisions. I defer to the DOJ for further supplement. Is there any similar provision under other legislation? Chairman, thank you. Thank you, member. These provisions are very similar to that of fixed penalty notices. Under the immigration ordinance, the proof of identity can cover a valid travel document, and that's really in the definition. Ms. Kong? Chairman, I am none the wiser with penalty notice. Now, for the purpose of giving the person a penalty notice, what's wrong with that? Now, here you require the personal information for the purpose of giving the penalty notice, and you have to fill in all these details in the penalty notice. Is that right? Do you have to fill out all the information in the penalty notice? I haven't quite seen the penalty notice, because this is limiting yourself for the purpose of giving. Do you really need to have all these information? Mr. Sheikh? Chairman, the penalty notice would include all these details, right? So we include the telephone and address. Yes, indeed, yes, if available. Right, I don't have any further question. I was just a little bit surprised. The personal service. Well, I understand now, because you have to fill in the information. Mr. Lai Tong Kwok? My understanding is that an officer has issued the fixed penalty ticket. If the person doesn't pay up, you have to chase it, and you have to issue a letter to them, to him, that there will be further reminders. Just a name will not do. At least you must have the address and the telephone number. Even for local residents with ID card or non-local resident with a valid travel document, you still have to do it. Now, when an address is given, if the address is outside of Hong Kong and he doesn't bother to respond to you or to your letter, that's another matter. But you must have the record there. When he comes back to Hong Kong, and if there is some outstanding payment, you can take action. So this kind of information sought is not so much for the purposes of issuing the ticket. Now, the ticket is issued to person A with the ID number, and there can be many people sharing the same names. And this will enable you to identify the person, to find the person for further action. And the fixed penalty would not be worth the paper is written on. It's just like littering. A similar arrangement there. That's my understanding, Chairman. Any supplement? If not, shall we move on? On page 21, we add clause 4 regarding power of arrest for specified officers. if someone refuses to give the particulars. And in Clause 5, the authorized officer has the power to issue the penalty notice. Page 22, we've added Clause 6. If someone has complied with the penalty notice, there would not be any prosecution or conviction. Clause 7, if someone fails to pay the penalty, then the demand notice can be issued accordingly. Page 23, we've added Clause 8. If someone complies with the demand notice, there will not be any prosecution or conviction. Yes, please hold it. Ms. Doreen Kong. Clause 8. I'm trying to put myself into the scenario. Now here, there is a penalty notice which has to be paid within 21 days, and thereafter a demand notice would be issued, and payment will have to be made within 10 days. If this is paid up, no more action to be taken. If I were the person, I would delay, I might delay until the demand notice is issued, because there is no penalty. If there is some further failure to pay up, you issue them with the demand notice, which has to be paid up within 10 days. Now, people are tempted not to pay the penalty straight away. Why is it like this? In terms of policy, it's too liberal, isn't it? If one doesn't pay up within 10 days, what's going to happen? No payment within 10 days? Chairman, thank you. We said many times that we are referencing the existing fixed penalty arrangement. We've seen many examples in relation to littering and other fixed penalty notices. People normally would pay up within the specified period. Ms. Kong, the reason I raise this, I heard from Mr. Lai Chung Kwok that this is the case with fixed penalty. I think we have to mull over this, because this is very much a loophole. People can delay payment, and institutionally you are encouraging people to do this, and you will have the whole system burdened with this, and they're not slapped with any further penalty. I understand that people may be forgetful, but there is no additional penalty, and this is a burden on the administrative system. I'm not asking you to make the changes now, but after mulling over this point last night, I would be tempted to not pay straight away. $5,000, the money in my pocket would be better if it is kept longer. Would that be a loophole there? Chairman, we'll find supplementary information, but when we look at the fixed penalty system, well, in theory, this is something that should be considered, but when it comes to the actual operation, we didn't identify anything toward that. Mr. Poche, well, any change will have knock-on effects on others. As the civilized society, we have this system, in particular for the traffic offenses. With a fixed penalty ticket, you're liable to lose it. And that's an additional opportunity for you to make the payment. And we're not really trying to make it too draconian. And this is the spirit that we should have, unless there are any serious situations. I don't think we should tighten up the room there, because this system has been serving us so well. And you may save the interest for 21 days, but as practice lawyers, we would give 7 days or 21 days grace period before we really resort to legal action. So this is really something or some attitude we should have in a civilized legal society. All right, you might wish to consider these points. Please carry on. Chairman, thank you. Pages 25 to 20 or 24, we have clause 9. The authority may withdraw the penalty notice or the demand notice. Pages 25 to 29, we've added 10 to 14. If the person served with the notice fails to make the payment, and there is such a recovery process for the fixed penalty. Hang on a sec, please. Mr. Porge, Chairman. I think there may be accidents. It is better for you to have an additional notice. Pages 29 to 30, we have clause 15. If after receiving the penalty notice, there would be a process for dispute of liability for the offense. Pages 31 through to 38, we have the ancillary amendments. Page 31, we have deleted the prohibition of feeding of wild animals, notice 1 on 1999. Since the feeding ban is applicable to the whole territory, so there is no need to specify the applicable areas. Page 32, Cap 102, Division 1, we have deleted the reference of nature warden and honorary nature warden to make it in line with the rest of the ordinance. And page 33, criminal procedure ordinance 1113C, we're making some amendments there to add the fixed penalty to the bill. 35 to 37, that's in relation to the court proceedings, electronic technology, magistrates' court rules, and all these are added to this so that the court can use electronic means. Thank you. All right, let me put this to members. Any further comments? Legal advisor, any questions? Chairman, thank you. For the English version of the bill, the Legal Service Division has compared the two versions. We haven't identified any particular discrepancies there. All right, we spent quite a bit of time on the clause-by-clause scrutiny, and members made really valuable comments. We're basically done with the clause-by-clause scrutiny, and there are points made by members that the administration has to consider, like the letter of appointment and so on. And let's hope that you will let us have a reply in writing regarding all these points. Basically, we have already covered the CSA made by the administration during the scrutiny. Any follow-up comments or any follow-up issues or any CSAs for that matter? If not, then we'll be awaiting the administration's response to the points that we've raised, and we'll be letting members know. And if members don't have any particular comments, we may not necessarily need to have any further meetings. And I'd like to put this to members about the resumption debate, the date there. Well, let me put this to the administration. When do you want to have the resumption debate? Or you'd like to talk to us further? Chairman, we can communicate with the clerk after meeting about the date. There are 2 points there. Now, we propose that this go into effect on the 1st of August. That would be sufficient time. And second, we have received really valuable comments from members. We need time to look into these. August 1st, a lot will be going into effect. Any other business? If not, the clerk will be notifying you of the response from the administration and see whether you need to see the merit of any further meetings. And then we can discuss with the administration about the date of the resumption debate. Unless members have any further comments, meeting is now adjourned. Thank you all very much.